Good afternoon, delegates. I'm Ruthi Rajan, Deputy Editor of the Oath Legal Magazine. Thank you for joining the inaugural session of the Oath GC Talk webinar series, a new initiative by the Oath Magazine. We hope that you're well, considering current circumstances. We are particularly grateful for the gifts of technology through which we can reach out to you and the rest of the legal fraternity, even during this time. Our first webinar is in association with the law firm Afridi and Angell. The session will focus on COVID-19 and employment in the UAE, led by Charles Laubach, partner at the firm. Charles has been practicing as a legal consultant in the UAE since 1986. He is well versed in all aspects of UAE and DIFC employment matters. During this webinar, Charles will discuss the impact of the measures implemented by the UAE authorities on the workforce during this pandemic. He will emphasize on how employers may apply these measures in a manner consistent with their long-term plans and strategies. With regard to the format of the session, Charles will first lead the session for the first half, and this will be followed by the Q&A session. Some of you have sent in your questions in advance. Thanks for that. These questions will be addressed during the presentation. Also, there is an option on your panel to type in and send in more queries. Please do avail of it. We will try our best to address these queries within the hour. Thank you. Over to you, Charles.
Thank you, Ruthi, and thank you for that kind introduction. Going please to the next slide. This is a brief introduction of the firm that I work with, Afridi and Angell. As Ruthi said, I've been here since 1986, practicing law in the UAE. The firm has been here since 1975, but this is the first time, and you've heard me speak, I think, before at other meetings of the Oath, other events on employment matters, but I've never before spoken about what to do during a pandemic. This is really a first. It's a first for all of us, I think, in the region, in the world. It is it's certainly a first for us trying to advise employers how to go through a very difficult economic phase and what to do with the huge overheads that haven't gone down, although revenues are going down. So I want to talk about some of the measures the UAE authorities have promulgated to guide the workforce, the employment sector through this time. And like I said, this is a first. All of the issues we're facing right now, or that the authorities are grappling with, are matters of first impression. As lawyers, we're dealing with matters of first impression. It's never a dull moment. I'm sure most of you are now working for the third week from home. Third week compulsorily, fifth week maybe voluntarily. And it really is a different dynamic, entirely different dynamic. And like Ruthi, I'm glad we have technology that enables us to stay in touch. Next slide, please. The various measures that I'm not going to talk about everything. There are requirements on going out and wearing masks and testing employees. I'll just touch on that very briefly, but I'm really only going to talk about workplace matters, okay? Because I think most of us are mainly concerned about that here. And if I talked about everything, it would take much, much longer than we have. So I want to just focus on some of the workplace initiatives that have been taken by the authorities in the UAE. And I think I'll start with this resolution promulgated at the end of March by the Ministry of Human Resources and Emiratization. It's resolution 279 of 2020. Has a number of interesting features. Now it allows employees to work remotely. Now that was brought in about 2 weeks after voluntary work from home programs began anyway. So it kind of was catching up with what is really happening. But it's certainly the case now that it's necessary now in Dubai. You've got to let your employees work from home. I hope you're all finding that it works all right if the technology is there, if your servers are there. But as a formal measure, you cannot terminate an employee for absenteeism just because the employee is working from home. I'm not sure what you're doing out there. A number of our employees actually are working from home. And by that, I mean their home countries. They've gone back to their home countries, but they're still checking in every day, UAE time, and logging onto the server and doing client work, but they're doing it from back in their home countries. Most of us are still here in Dubai, but a few are not. A few other measures that have been introduced to deal with the workforce, some of them, working from home doesn't really save you any costs. It just means the employees can maintain social distancing, and you can keep the files going, keep the work going, even when your people aren't really in the office, because they're effectively there, virtually there. But you can also, the resolution also allows employers to put employees on paid leave. Now, all employees get 30 days of paid leave every year anyway. What this and the ministry, the labor law allows employers to schedule that paid leave at their option. And you can break it up into no more than 2 segments, but you can basically tell employees, if you want, take your paid leave now, and hopefully by the time it's over, the COVID crisis will be over and you can come back to work and we can get our business going again. But the resolution addresses this anyway, so employers who wish to put their, some of their personnel on paid leave may do so. A more radical step to take is putting the employees on unpaid leave. And this is a measure where the ministry has also promulgated an addendum to the employment contract, which the employer and employee are supposed to sign. You are not required to file it with the ministry unless asked to do so, but you're supposed to have it signed to document the fact that the employee is going on unpaid leave with effect from X date, and it can be for either a term of weeks, or it can be for the duration of the COVID crisis. Up to you to agree on that, but that's what many employers are doing. If an employer goes to its workforce and says, look, we need to cut our payroll overhead by 75%, and we can do it by either placing 75% of you on unpaid leave or terminating your services, most employers are going to take the unpaid leave option. But it's got to be done using the ministry form. It must be agreed by both the employer and the employee. The employer cannot impose it unilaterally. The employee is supposed to agree to it. Other options, which are a little bit more, perhaps a little tougher, a little more frugal, would be a temporary reduction in pay. Again, that has always been available to employers. We've had clients do this in the past when there have been economic problems. Some industries are very cyclical, so you'll see some industries, raise and lower pay of their workforce in accordance with the business cycles. This is not really all that new, but you do need to get, again, the employee's consent if you're going to reduce pay. And again, it's the same form, the ministry's form, whereby both the employer and the employee agree on the adjusted compensation the employee will be receiving for the duration of the COVID crisis. Now, I've been asked some questions. Employees receive different components of compensation. They receive base salary, they may receive some allowances, they may receive some in-kind payments as well, like use of a company car perhaps, or something along those lines. And the ministry does not dictate that you've got to reduce certain things and not others. So it's, again, entirely up to the employer and the employee to reach agreement on what elements, what components of salary are going to be reduced as a temporary measure. Some employers are doing it across, it can be allowances and base salary by the same proportion, or it can be only allowances or only base salary. Whatever is agreeable, whatever really, again, the main thing here is to reduce the payroll overhead so the employer can remain solvent. That's the bottom line. If you're insolvent, you go out of business, and that's nobody wants that. Some employers are taking a more drastic step, which is implementing a permanent reduction in pay for all or part of the workforce. Now, that is a little bit different from the temporary reduction in pay. You don't do that by filling in and signing the ministry form. Instead, you have to actually go through the ministry portal and reduce the salary of the affected employee or employees through the ministry portal. Again, the employee's consent is required. They've got to sign. You've got to have a new contract with the new benefits and register that with the ministry. And of course, you've got to then amend your WPS records so that you have consistency in terms of the contract and the salary and the bank records. It all is mutually consistent. So these are, again, these aren't really drastic changes in law as such, because all of these provisions were there before. But the ministry is trying to guide employers through this crisis and say, look, don't run off and fire your personnel as a first step. Try these other methods first to manage your payroll overhead, and then we can move on. You know, it says, look at these measures in sequence. Don't just rush to the most drastic measure first. The ministry has introduced something called a virtual labor market. And so if you're going to terminate the services of an employee or put the employee on garden leave or unpaid leave, you're supposed to also, the employer or the employee can do this, register the particulars of the job with a virtual labor force, again, at the ministry. It's all done online. And that is supposed to enable other employers that may wish to look at this employee's credentials and they can fill a position if they need to. It's very early days. I don't have a good feel myself for how this is working in practice, but it is a way to try and let the employees know that they're still, you know, in the job market, even though their benefits are being reduced, or even though they might be on unpaid leave for a number of weeks. Again, that is the major measure that the Ministry of Labor has taken with regard to the private sector workforce. A couple of observations on this, mainly as to scope, because I've been asked this question previously. This is an initiative of the Federal Ministry of Human Resources and Amortization. It only covers employees or employers that have a employer file with that ministry. And what that means is that, number one, employers that are not covered by the labor law are not covered by this resolution. So again, government employees, military security personnel, domestic servants, agricultural laborers, anybody else who's not subject to the labor law would also not be subject to this particular set of facilities. Also, the resolution does not apply to personnel in free zones, because in the free zones, your employees in the free zones do not have labor permits issued by the Ministry of Human Resources and Amortization. Instead, they're approved by the free zone authority. So again, DMCC, Jebel Ali, DIFC, and all the rest are not subject to this resolution. Some employers might be interested in trying these measures anyway, and I suppose you could do that, but the general idea is going to be, number one, for the unpaid leave and reduction in compensation, you still need the employee's consent, and instead of filing with the Ministry of Labor, you file with the relevant free zone authority. But as a matter of just, you know, strictly applicable regulation, this resolution would not apply in those free zones. Some people have asked me, what do you do if an employee will not accept a reduction, either unpaid leave or a temporary or permanent reduction in salary? And that brings up a further point. All of these resolutions are introduced on top of an existing regulatory system, and the previous, labor law remains in effect. The other regulations that have been promulgated remain in effect. So if an employee, if you need to reduce your payroll and the workforce does not cooperate with that, all or part of the workforce does not, you might be compelled to give the employees that are affected and that are not cooperative notice of termination, okay? And that is the same as you would do it any other way. You give them notice in writing. You would follow the notice period that is stated in the contract. You would you would try to base this on a legitimate reason for termination. In this case, it's going to be the COVID crisis and the need to reduce workforce, basically redundancy. The courts are kind of all over the place on that. Sometimes they hold, as a matter of fact, that it's legitimate. Other times they don't. It's the employer's, the exposure there, the delta, is either 1 month salary as termination notice of termination, or it's 3 months salary as damages for wrongful termination. But the employees can't claim more than that. So if you're going to terminate an employee because you are compelled to do so, well, you can do it, but you've got to, again, pay the employee the whole severance package, the notice salary, the end of service gratuity, unpaid leave, and all of that, and perhaps pay 3 months salary as damages for wrongful termination. It is not generally what employers are doing. I think all of us realize that when this crisis is over, we're going to want our people back. And so, you know, you hope you can keep them on board, you know, keep your talent intact for the duration of this crisis by either putting people on, you know, unpaid leave or reduced compensation packages and hope they stay around. But, you know, if you got a large workforce, that's not going to happen for everybody. So, you know, some people are going to be, I think, compelled to look at termination options. Sad but true. Let me move on to the next slide. Quite a long time about this one. The next slide talks about ministerial resolution number 280, and I want to bring this to your attention for a very specific reason. Everything I just told you about 279 applies to employees who obtain labor permits issued by the Ministry of Human Resources and Amortization. Perhaps the most important category of employees that do not fall in that category are UAE nationals. And so I want you to be aware that if you want to reduce the salary or put on leave or do anything like that for UAE national, it's a different set of rules. And basically there's a committee that the ministry has formed to try to, maintain the government's amortization objectives during this crisis. And it's an entirely different set of guidelines for if you wish to introduce any of these measures for a UAE national. It's in fact much more difficult. It requires government compensation. There's a committee the ministry has formed to look into this. So again, if you're going to take measures to reduce payroll overhead, you're going to have to treat the UAE nationals a little bit differently from everybody else. And it's not so different from any other measures you're going to take during normal times. Next slide, please. The ministry has also promulgated a resolution that generally deals with safe workplaces. And when you read this resolution, number 281, you might think that it only applies to construction companies that are bringing laborers from, you know, labor accommodation to a work site and taking them back. But we've actually, because it has requirements in there about testing employees when they arrive at work, when they leave from work for symptoms of COVID, and generally maintaining a safe workplace and maintaining social distancing. The ministry has informed us that we have that this is not applicable only in the construction sector, but is applicable throughout the economy. And many of you might have gone shopping and seen that some of the supermarkets there, they have thermometers, they test you as you come in. And that's kind of what employers are supposed to do too. So number one, at the workplace, observe social distancing. Do not bring in more than 30% of your staff. Do not bring in more than 30% of your capacity to hold members of the public. Those thresholds are still in effect. When offices reopen again, after this current crisis is over, the current sequestration is over, might be at the end of next week, that rule will stay in effect. So you'll have to keep on observing this 30% of your workforce and of the public visiting your workplace when the current quarantine is over. It is also a requirement that when the employees come to you twice a day to just check the employees for not give them the COVID test, but test them for symptoms. Thermometer, cough, runny nose, headache, stuff like that. I guess you can ask the employees any other symptoms, but I think we're going to have to start taking the temperatures of employees when offices in Dubai reopen, if it's next week. So be ready for that. The ministry hasn't been policing this, but I think they will, because what we don't want is to flatten the curve and have it go back up again because people just lose their vigilance. It's going to be important to keep the curve flat and to push it down a bit, and that means maintaining safe workplaces once workplaces open up again. So this resolution 281 is an important one to watch when again we're allowed to go back to work. Some of you might have seen that now in Dubai, at least, if you go outside of your residence, you have to get a movement permit. If you're walking, driving, bicycling, whatever, you've got to wear masks and gloves when you're outside. This is not true throughout the UAE, but here in Dubai, the movement permit is required, and the mask and gloves are absolutely required. In Sharjah and Abu Dhabi, you can still move around, but again, the requirements are a little bit different from emirate to emirate. So just make sure wherever you are, you know what the requirements are to move around within your emirate. The requirements of 281, which are on this slide still, those apply throughout the UAE. But Sandhya, next requirement, next slide. These other measures are what we're facing in Dubai right now, and at least in terms of masks and gloves and social distancing and all that, those are being observed to a greater or lesser extent in almost all of the emirates. And next slide, please. I just want to bring your attention to a couple of to the overall framework, because the UAE authorities, although this is a unique crisis that came upon us very, very quickly, they're handling it in a pretty good way. That is, there's a system in place, a plan in place, a legislative regulatory framework in place which the authorities are following. There are federal initiatives and there are local initiatives within each emirate that differ a little bit, but the federal ones apply throughout the UAE. And you'll see in the press a lot of references to the National Emergency Crisis and Disaster Management Authority, which actually goes back to 2011, and 9 years ago. There was a federal law on communicable diseases. COVID has been added to this under that law. So the measures that are taken by the authorities under that statute apply now to COVID. You probably have seen reports of a cabinet resolution which delegated authority to the law enforcement authorities in the UAE to impose fines and even imprisonment for violating public health measures. And then resolution 38 of 2020 is the one that got a lot of attention a couple of weeks ago that defines the various penalties. If you're driving in Dubai without a mask and the police stop you and impose a fine of 1,000 dirhams, it's under that resolution, 38 of 2020. That's where the authority comes from. It's not being done arbitrarily. It's not being done in an ad hoc way. There's a system for all this. There's also a cyber crimes law, which I think you all know about. It's not new, but you might have seen some press reports of people who have been sanctioned for putting perhaps sarcastic or snide videos on social media. Don't do that, folks. It's never good to take measures like this lightly. And I think, next slide, please, Sandhya. I think that brings me really, for now, to the end of my prepared remarks. It's now about 3:30, and I think I've addressed most of the questions that came up in the written questions that you sent in earlier. But I think with that, Ruthie, Sandhya, I'm ready to take more questions if there are any, or if I haven't covered anything.
Yes,
okay.
Yes, thank you, Charles. We do have a few more questions that have come in, which I'm going to read to you. First one is, how critical is it to have a physical office for all employees under the UAE law?
Oh, okay, well, let's talk about that in normal times. When we don't have a COVID crisis, The general requirement in most parts of the UAE, and it's different in some free zones, but in most of the UAE, to get to operate a business, you need a license for the business. And the license has got to be based on suitable commercial premises for the business. So, and again, the authorities want to make sure you have a lease with the landlord for the building where your office is located, or the warehouse, or whatever it might be. They want to also make sure it's suitable for the employees, for your personnel. It's not overcrowded. In fact, in some free zones, you get a visa quota based on the size of your office. They also want to make sure it's safe, and you'll even get the civil defense coming around to inspect from time to time. They'll want to see things like medical kits and fire extinguishers and all the rest of that. So in normal times, you're supposed to have an office that's at least big enough for your staff. Now, in some free zones, you don't need to do that because there are things called a flexi desk option. And so that really is a question of the individual rules of the various free zones, but you can go in with maybe 3, 4, 5, 6 people, and you don't have a desk or an office that's always yours. It's a flexi desk. It is a number where someone can call or email you, and there's a virtual office of some kind, and that goes on. You can still sponsor visas, you can still open bank accounts and do everything else a business can do without having a physical office. And that's in fact a very attractive option for people to want to come in and set up a business with low overhead to start. Now, there's no difference now in the time of COVID-19. If people go to your office, you should still maintain social distancing. You should not go to the office when you're under quarantine, as we are now in Dubai. And if you do go to the office, you go there to fix a server or to pick up a FedEx package or whatever it might be, get a movement permit first and make sure you comply with the movement permit's restrictions. So the physical office thing is really COVID. There's no real difference in how you treat it. If you've got a flexi desk, again, wherever the flexi desk is located, whatever corporate services provider you're getting that flexi desk from, the same rules apply. Masks, gloves, social distancing, movement permits, everything. Okay, so does that answer your question? Hope so.
Okay, great. The next one is, can employees who are stuck overseas and cannot get back to the UAE be made redundant? What rules apply? Does the company still have to enter them on the job seeker portal and pay allowances?
Yes. The general rule in the labor law is that you cannot terminate an employee. You cannot give an employee notice of termination while the employee is on leave. So the question then is the employee in question on leave? I think in most cases, the answer is going to be yes. Now, if the employee proceeded on annual leave before the COVID crisis hit, or some other kind of leave, and now is stuck overseas, yeah, this is a real issue because presumably the employee is working remotely. Now, maybe that's a bit of a hard thing to say, but for us, we're a law firm, Afridi Angell. Our lawyers can really work almost from anywhere in the world as long as they have a Wi-Fi connection. So we do have lawyers. They're not on leave. They're simply working from home, and in some cases, their home is in their home country, and that's fine for us. They can still function. If an employee is on annual leave, actually one of our personnel, not a lawyer but an admin staff, is on extended annual leave because he is stuck outside the country. Now we're not going to fire him just because of that. I think it's a bit harsh to say the employee is absent or remaining away from work under like Article 120 of the labor law and terminate. You just can't do that. Leave is not the time to terminate an employee. If you want to terminate an employee, you're going to have to wait for the leave to end. If they overstay, now what about this? What if they overstay and after the COVID-19 crisis is over and flights resume and they can return to the UAE and choose not to, then maybe you can terminate for overstay. But until you reach that point, the answer probably is no, you can't. And if you want to do things like reduce compensation or switch an employee from paid to unpaid leave while they are on leave, again, you aren't really supposed to do that. But I think if the employee signs that form, and that form is, the form that is attached to Resolution 279, and again, the employee is not coerced but voluntarily agrees to change status, you can probably do that. But it is a very unusual. A lot of these questions no one ever asked before because these are unique times. But I don't think the ministry wants employers to use this as some kind of a pretext to treat employees in a especially harsh or vindictive way. And you're going to have to, I think they want to keep the workforce intact. The ministry, I think, wants to keep talent in the UAE. They don't want to see people going home and never coming back, because when we reopen again, what's going to happen then? The ministry is worried about a national problem. And so I don't think they want to let employers have some kind of carte blanche to reduce the workforce per force just because of the difficulties we're all facing. So I think that kind of answers your question, although I think the real answer is going to come out when we see how long this crisis continues.
Thank you, Charles. Our next question is, does the Resolution 279 of 2020 apply to employees who are on probation? There's one more related to it. Can an employer terminate employees on probation if they are deemed to be in excess of surplus requirements, considering Article 3 of Resolution 279?
If an employee is on probation, you don't even have to look at the resolution. The pre-existing provisions of the labor law still apply, and an employee on probation can be terminated at the convenience of the employer. You don't need a reason, you don't need notice, it can just be done. So I don't think you reach the issue of what provision of Resolution 279 you actually are dealing with. Let me go back to that though. So the general answer is that an employee on probation, I mean, the whole purpose of probation is because you realize it might work, it might not. You don't want to have to go looking for a reason to terminate an employee on probation. Now, if you want to convert an employee who is on probation to unpaid leave or to reduce their salary, you can do that. It's still going to mean filling in the form that's attached to Resolution 279. And also bear in mind that once the employee passes the probation period, then they become a regular employee of the company, and you're going to need to have a legitimate reason for termination of services. You can't just do it at will anymore once the probation period has been completed. Okay, I hope that answers the question.
Okay, great. Thanks, Charles. Can an employee request the staff to take all annual leave for 2020 between Q2 and Q3? Failing to do so, the paid leave not taken would be forfeited for 2020. A note is added. Annual leave cycle would then be less than 12 months. The same delegate has asked one more question. Can we change the HR policy within the same year we implement the change, or can it be only valid for the following year?
Okay. Annual leave, the employer can schedule annual leave, and what you can't reduce it, and the employee does not forfeit it, but you can schedule it. So if you wish to compel all of your personnel, or say half of them, or whatever, a certain number of them, to take their annual leave now, you can do that. That is absolutely in the employer's powers. What you can't do is say, take your annual leave now, or else you lose it, because they don't lose it. But it is within the, you could say, take your annual leave now, or you'll be fired because you're not complying with the employer's rights to schedule annual leave. But again, bear in mind that if leave is not used during a specific year, it is carried forward to the next year. And any unused leave when service has come to an end is cashed in. So again, the employee does not sick leave if you don't use it. If you don't get sick and you're lucky, that's it. It's never you lose it. Use it or lose it, and hope. And if you're lucky, you don't get sick. You don't need sick leave. That's good. It's a good thing to lose. Annual leave, you never lose. You either carry it forward, or you cash it in, or you use it. There's no other option. You don't lose it. A provision in the contract requiring an employee to forfeit annual leave would not be enforceable. Now, your last question on HR policies, you can change those anytime. And when they become enforceable depends upon the nature of the policy. But again, the best practices are to make sure that major changes in policies are notified to all of the employees, either physically posted in the workplace or put on your website. If you've got disciplinary measures in the HR policies, those should be approved by the Ministry of Human Resources and Organization. But if it's just a question about general rules on conduct of the office and integrity and so on and so forth, those kind of changes you can really introduce from time to time, whenever. And unless they introduce some kind of burden on the employee or change compensation, you can introduce them pretty much with immediate effect from when they are introduced. So it can be for during 2020 or prospectively for 2021 or whatever. So I think you're free to change HR policies pretty much whenever you wish to do so as the employer. Okay.
Okay, thanks, Charles. I think there's one question on, do allowances need to be paid in cash if we terminate an employee now?
If you terminate an employee now, I see there's actually a couple of questions, a couple of things there. Let's say you actually go through termination, okay? And I think in that case, the answer would be yes. You would have to calculate the entire severance package to which the employee is entitled. And that will include notice salary, notice salary is base salary and allowances. It'll include end of service gratuity. It'll include any unused leave. So you cannot terminate the employee's visa unless you pay that to the employee. The employee, as part of the visa cancellation process, recites that he has received all of his entitlements. And so you pay that to the employee's visa is canceled. The big problem now is repatriation of the employee. And that's going to be, it looks like right now you can get the employee off your payroll, off WPS, basically cancel the labor permit and cancel the visa too, but the visa won't actually be canceled until the employee leaves the country or transfers. And leaving the country right now is a problem. One of the reasons I think for this virtual labor market is so that employees who are leaving one employer can be picked up as quickly as possible by other employers who are looking to hire new personnel. And bear in mind also that this is a different subject entirely, but if you hire an employee in the local labor market, you don't have to go through the Tautin procedures if you hire them within 90 days of when they left their previous employer. So in a way, it's good to hire in the local market. But there is a problem right now, and how it's ultimately going to be resolved is unclear. But employees who leave now and cannot go home are kind of in limbo land. It looks as though there's an obligation at least to maintain their major medical insurance coverage up until they depart the UAE, so that you don't have people hanging around here unable to leave who are uninsured. And of course, if you're going to put them on unpaid leave, that isn't really completely unpaid. It means that you still have to, number one, sponsor their visa. Number two, provide a health insurance, as that goes along with the visa. And if you provide them accommodation as is often the case for some employees, you've got to provide that too. So unpaid leave isn't really leave with nothing. It's leave with, you know, the basic, the parts of the compensation that are not cash. Okay, does that answer the question?
I hope so. Thanks, Charles. I have a scenario presented to me. If an employee is terminated during this time and the employee was paid all the legally entitled benefits, which include 1 month notice pay, vacation balance, end of service gratuity, flight and repatriation cost, would this still be regarded as an arbitrary dismissal, and would the employee be entitled to 3 months salary for the arbitrary dismissal, as the employee actually received more than what he is entitled to under Resolution 279. I hope you followed it.
Yeah, I got you. Well, 279 again does not. 279 does not mandate what employees receive when services are terminated. Instead, termination of services, you go back to the labor law. And again, in the scenario you just presented, the employee is getting everything the employee is entitled to, and then you cancel the visa and the employee goes home. Can the employee come back and sue you for additional entitlements that may or may not be alleged? And I have a rather inconvenient answer to that. And the inconvenient answer is that the only real safe harbor an employer has, you know, even if the employee signs a waiver, a release, an acknowledgement that everything has been paid, even if that's done, the only real safe harbor for the employee, for the employer, is the passing of 1 year from the date that the employee's visa is canceled. Because after 1 year goes by, a labor claim, if there is one, becomes time barred. So within that 1 year period, it is possible in theory, for an employee to bring suit against the employer for, they can say, I was terminated for reasons of redundancy, nothing to do with my performance. It was instead just because the employer had to save money, and that isn't legitimate, and I challenge it, and they go to court. What will happen? Well, the question then is, did the employer have a legitimate reason, which is the term used in Article 117 of the Labor Law? Did the employer have a legitimate reason for termination of the employee's services? Now, my own view, which is just my view, is that if you're reducing headcount in a time of severe economic stress like this, that's a good enough reason. And I think any sensible court would agree with me. But I could be wrong. And what really happens here is that the case will go before a judge or a panel of judges, and they will make their own determination as an issue of fact as to whether the employer had a legitimate reason for termination of this employee's services. So you might have to go into court and say, well, Your Honor, we were faced with a drastic fall in turnover, and we had to cut our payroll overhead by 40%. And we just chose the most expensive members of our workforce to terminate because that was the easiest way to reduce payroll overhead. And so we did that, and that was legitimate and that was reasonable. What will the court do? It's a question of fact in each case. And each time courts look at this kind of issue, they make their own determination of the facts of this one case before them as to whether termination was legitimate or not. And so you're going to be faced with a claim potentially. Now, maybe the employee will not come back and claim for the additional, delta, 2 more months or 3 more months of compensation. Maybe the employee will. Often they're off, pursuing the rest of their career, maybe not. And so my impression is that once the employee signs the waiver, cancels the visa, leaves the country, very rarely do claims get filed afterwards, but they can be filed as a matter of law. And the judge could possibly fine for the employee if he agrees that the employee was terminated for a reason that was not a legitimate reason under the labor law. So that's kind of what happens. You never know for sure until a year goes by.
Thank you, Charles. We have about 10 minutes left in the webinar. We still have a few questions, so I'm going to probably ask a couple of more. What are the penalties for breaching Ministerial Resolution 279? The penalties for breaching.
Yeah, well, there would be I don't remember what they are exactly. There's a whole bunch of penalties for employers. Well, let me walk you through it, because here's what can happen. I mean, there are lots of them. Okay, the most serious breach is that the employer is exposed to a labor claim, and so it's the civil claim is usually the most significant element of exposure. And again, if you were going to terminate the entire workforce in one go, you had to say 50 people. 50 claims is a lot of money. It's a lot of aggravation. It's a lot of, number one, it's money for lawyers, money for the courts, and possibly money in damages. So there's that, civil exposure. Now, if the Ministry of Human Resources and Amortization forms the view that you are engaging in a regular pattern of unfair labor practices, they can sanction you too. They can impose fines, they can give you warnings, they can reduce the level. You can go from a category A to a category B employer, which makes it much more difficult to hire new personnel and more expensive. You can even be barred from hiring new personnel. Your file can be frozen. So again, that's not just because of that's not one breach or one wrongful act. That would be a pattern of acts that the Ministry of Labor views as unfair or improper. So the worst penalty of all probably is having your file frozen, because that means you can't do anything that requires a proceeding by the Ministry of Human Resources and Amortization. You can't hire anyone, you can't fire anyone, you can't recruit anyone, you're just frozen. So you've got to, at that point, rectify the problem. So there's a whole series of administrative penalties that the ministry could impose on you. There's exposure to civil liability if the employee that is affected has a bona fide claim. And of course, you can have your file frozen. Okay?
Thanks, Charles. If visas are to expire post March 1 are valid to December, does this apply automatically, or employee or the employer must apply for such an extension?
Yeah, good question. I think what that is designed to do, I think right now you don't need to apply. And different categories of people that this is relevant to. First of all, there are people who hold UAE residence visas, okay, who are outside the country. And they cannot come back perhaps during the COVID crisis because there's no air services. And they might very well overstay they might stay outside the country for more than 6 months. And if that's the case, I know people in this situation, in fact, the authorities have said that visa remains valid. So even if you overstay your residence visa and you come back to the UAE after more than 6 months have elapsed, you can still enter the UAE. So that the people who are outside the country, this is for them, and that's a very good thing, I think. If people are inside the UAE, the question is, the question then is, maybe you can't get visas renewed right now because the procedures are so difficult. As you might have seen, the UAE is moving more and more government functions now are moving online, and labor matters, court matters, many things are going online now. We have been getting documents signed and notarized online without ever having to go into the notary's office. We have had all kinds of transactions are moving online now, and I think it might be the case soon of for visas as well, but perhaps not in every case. So I think if you have, as an employer, if you've got employees whose visas are due for renewal and they're here in the country, but you can't renew the visas because of the COVID crisis, I think the message there is you don't really have to worry. The visas will remain valid at least until the end of the year, and you can renew them in due course. I don't think I'd wait until the end of the year. I think, however, if procedures are back to normal, when the visa, as soon as they're back to normal, try to get the visa renewed following the normal procedures, just because it's better that way. But at least you're not going to have to worry about an employee being in the country, illegally on an expired visa, because that isn't going to happen. But I don't think I'd just wait until the end of this. What if you wait until the end of December, and you have then 60 visas to renew? That'll be a real rush. You might want to do them, in installments over time once the COVID crisis lifts a bit and government functioning is back to normal. I'm assuming that's going to happen over the summer. I hope we are not talking about the same thing in the same. I hope we're better off in December than we are now. But again, I don't know how long this crisis is going to go on. But don't as a matter of prudence, don't let all of your visas go until December before you decide to renew them. I would attend to them as soon as you can. It's just that you're not going to be penalized for having, workers with expired visas. Does that address the question?
And related to that was, does this new date to show on the GDFRA/AMER system, or is it assumed?
Could you please repeat that question? I didn't hear it very well.
Yeah, whether this date to show on the GDFRA or the AMER system, or is it assumed? It was added to the first question that I asked, so I'm guessing it's related to it.
Well, I think the visa will stay valid until the end of the year. But if it's an employee visa, like I said, I think what you want to do as a matter of prudence is renew them once the normal visa renewal processes come back. I wouldn't wait until December. I wouldn't wait all the year.
Okay, Charles, we do have a few more questions, but I know that we're also running out of time. But I'm sure we can probably address some of the questions that we weren't able to get to post-event, probably via document or directly. I think that should work. Is there any concluding statements that you'd like to add?
Well, all I can say is thank you to all of the participants for your time and attention and for your questions, because the questions to me are more interesting than the presentation. It's always that way. And again, these are all questions that no one has ever had to deal with before. So it's unique times. And I want to thank the Oath for putting this together. And I hope it's been useful. And I also hope we don't have to do this anymore. I hope the crisis goes away soon. But thank you very much for your attention.
Thank you. With that, we have come to the end of the webinar. Thank you, Charles, for taking us through the topic. You've shared key information that is both useful and practical for our delegates. Our thanks also to Samara and Jeanette at Afridi and Angell for helping us put this session, and also to Sunil and Sandhya at Niche Publishers for their support. Thank you for joining the session. We definitely had a few more questions that we had to answer, but we're just keeping with the time. Please do write to us if there are any specific queries that we may have missed out during the session, and we can definitely get back to you. We will keep you posted of other events in the webinar series. Thank you for your time. We wish you good health. Have a great week.